Here's a clear, exam-ready explanation of the topic. Exclusion of oral evidence by documentary evidence. Sections 91 and 92 of Indian Evidence Act, 1872. Introduction. In cases involving written documents, the Indian Evidence Act prioritizes documentary evidence over oral statements to ensure accuracy and reliability. This principle is expressed through Sections 91 and 92, commonly known as the best evidence rule. Section 91, evidence of terms of contract, grant, or disposition of property. When the terms of a contract or grant or other disposition of property have been reduced to the form of a document, no evidence shall be given in proof of those terms except the document itself. Key points under Section 91. Point. Explanation. Applies to contracts, grants, and property transfers reduced to writing. Primary rule. Document itself must be produced, not oral evidence of its content. Excludes oral agreements in place of written ones. Exceptions. Secondary evidence allowed under Sections 63 to 65 if original is lost or destroyed. Oral evidence allowed for collateral facts not directly part of the terms. Hatch example. How A and B sign a written contract for the sale of a house. Later, A claims an oral condition was agreed to. Under Section 91, oral evidence is not allowed to vary or contradict the written terms. Section 92, exclusion of oral evidence to vary written terms. When the terms of any such contract, grant, or disposition have been proved, no evidence of oral agreement or statement shall be admitted for the purpose of contradicting, varying, adding to, or subtracting from its terms. Key points under Section 92. Point. Explanation. Applies when written document is already proved under Section 91. Oral evidence not allowed to vary, contradict, add to, or subtract from written terms. Reason. To prevent false claims and maintain certainty in transactions. Exceptions under provisos to Section 92. Proviso. Exception. 1. Oral evidence about invalidity of document, fraud, illegality, mistake is allowed. 2. Evidence of a separate oral agreement on a distinct matter can be given. Oral agreement condition precedent to operation of written contract. 4. Oral agreement to modify or rescind a written contract is allowed if not required to be in writing. 5. Usage or custom can be proved to explain meaning. 6. Facts showing how language is used in practice may be introduced. ESNO, case, citation, principle. 1. Rupkumar v. Mohan Thadani, AR 2003 SC 2418. Oral evidence can't contradict terms of written agreement. Bahira Devi v. Official Assignee, AR 1958 SC 448, Sections 91 and 92 aim to ensure certainty in documents. Gangabai v. AR 1982 SC 20. Fraud or mistake can be proved through oral evidence. 4. Tulsi v. Chandrika Prasad, AR 2006 SC 3359. Exceptions allow oral evidence in certain special circumstances. Difference between Section 91 and Section 92. Feature. Section 91, Section 92 nature, substantive rule of law, rule of evidence, focus, deals with proof of existence of document, deals with effect of document. Oral evidence, not allowed when written document exists, not allowed to contradict proved document. Exceptions. Secondary evidence, if primary lost. Multiple detailed exceptions, fraud, mistake, usage, etc. Conclusion. Sections 91 and 92 promote the principle that written documents are the best proof of their terms. While oral evidence is generally excluded, certain justified exceptions are allowed to ensure justice and fairness.